We'll get started in a moment. I have 1 o'clock by one watch. Are y'all ready to go?
Yes, Your Honor.
Do we have a court reporter?
Yes, ma'am.
Oh, good. Okay, great.
I don't see opposing counsel yet.
Oh, yeah, okay. Has anyone talked to Mr. Gowans? Because I know he said he was going to be, oh, there he is. Okay, great.
I apologize, Your Honor. I was having a little bit of technical difficulties logging in.
I still show us as having a couple of minutes. So give me one moment. Ms. Davis, what agency are you with?
I'm sorry, Your Honor. I'm with Steno.
Okay. Do you mind giving me your, well, don't give me your telephone number and I'll tell you why in just a moment, but if you could put it in chat at some point.
Sure.
Okay.
And would you like my email address as well?
Just telephone number. All right, are we ready to get started?
Yes, Your Honor.
Yes,
You
Your
ready?
Honor.
You ready, Ms. Davis?
Yes, Your Honor.
All right. Good afternoon. This is North Georgia. I don't know what the name is now. I think North Georgia Builders LLC versus Mr. and Ms. Beard. This is 24 CV 010810. Today is the third day of our non-jury trial, and it is reserved for closing arguments. I do just want to note as we begin, I am in the courtroom, but we do not have a sheriff in the courtroom. So the courtroom itself is closed. Accordingly, if you look at the top of your monitor, you'll see an icon for YouTube. Do not be alarmed. We are live streaming on the court's YouTube channel. And then as soon as we complete the hearing, and that simply gives it an aspect of public access, which would have been the case were the courtroom open. So it'll be on YouTube, and as soon as we finish, it will be deleted. So with that, Mr. Gowans, would you like to go first or last?
I will defer, Your Honor.
All right, Ms. Rose.
Thank you, Your Honor. And one quick housekeeping tip when we left gathering the exhibits for the court reporter, the deposition transcript that I tendered at court wasn't entered into evidence, although it was electronically filed in November, and opposing counsel agreed and stipulated we can mark that as exhibit 100 into evidence.
Okay.
I have no objection, Your Honor.
All right. Thank you. And
Thank you.
And that's the original that I opened.
Yes, ma'am.
Okay, because it is in the digital is in the record. Okay.
Correct. Thank you.
Whenever you're ready.
May it please the court. This case is not about a homeowner refusing to pay for completed work. It's about a contractor who breached a written contract, disregarded permitting requirements, performed substandard incomplete work, failed to correct work under a contract term, but yet attempted to force payments as a precedent before performing repairs and work obligated to do so, suing my clients for $93,000 based on 2 unsigned change orders, an inflated invoice for work allegedly performed after spring break between the weeks 6 through 10, despite lack of work on site. When the facts are viewed against the contract language, the testimony of the parties, and the evidence presented, plaintiff failed to prove his case of breach of contract. To the contrary, the evidence established he breached his contract first, failed to correct repairs, was negligent, and repeatedly caused damage to my clients. The undisputed facts show the Beards paid $210,819 for work allegedly performed weeks 1 through 5 in response to invoices sent from North Georgia. The work included demolition and framing of a basement and first floor to support a new second level to be added, all without a permit and with approved or finalized engineering plans. The Beards funded this amount with their own funds. Despite their award of insurance proceeds of approximately $400,000, this dispute was initiated when the Beards' third-party inspections were failed, such that the release of the escrowed funds in April and May were not provided.
Ms. Rose, as I understand it, one disbursement was allowed by the insurance company.
Yes, prior to the dispute. The second and third draw request with an inspection in April and May were denied.
Okay. Well, was the $210,000 that the Beards paid over and above the insurance that was approved, the one payment that was approved? What's that
So
number?
the 210 was paid and funded by themselves from them. To the extent the insurance released a payment under the draw, it was to reimburse them after they had submitted their own cash. Just by nature of a draw request. A draw request is a reimbursement of funds they've already paid.
Right, but it goes back into their pockets, correct? I mean, if they said they paid out $210,000, but then they got reimbursed $200,000, they're really only out $10,000, right? And I'm just trying to figure out if that amount includes insurance or is over and above insurance.
I don't know that it came out at trial, the amount of draw of the first draw that reimbursed them towards the 210. But what
that's a good answer. Don't make it up.
Okay.
Keep going.
Yeah. Oh no. Yeah. Instead of assisting the Beards to complete work per the contract to fix the work, or to show that the alleged work on site matched with the draw request, North Georgia demobilized and abandoned the job May 16th or 17th. Under the contract prepared by the contractor, he was required, 1, to obtain a building permit. 3 times this is noted in the contract. 2, he was required to perform structural work in a workmanlike manner, free of defects, and fix any defects that necessitated repairs. 3rd, he was required to obtain written authorization for change orders before charging for additional work. And the last item I combined with number 2 was to correct the work he had performed. The plaintiff did none of these things. While he submitted an application for a permit, the plans were rejected multiple times by the city, and he never secured a permit or approved structural engineer drawings. Despite that, he commenced structural work, the demolition and framing on the 2 levels, basement and first level, to ensure that those 2 levels could support the load of an additional second-story level structural work. Plaintiff's expert Mark Cordell testified that 1, his first step or his recommendation of the first item that should have occurred was a demolition permit. He said, quote, "It was imperative for these plans as standard protocol to strip the site to a level to be rebuilt." He said this would require removing the roof and all ceilings to install the second floor system and walls. Based on his assessment, the entire home needed to be brought up to code as it exceeded the 50% value. Plaintiff conceded he never completed the city required pre-construction meeting. Instead, he commenced demolition, partial framing, and sending invoices. At no point, as the licensed general contractor, did he decide to halt construction and address the lack of permit, the status of the completed or lack of plans, or pause the work. He continued onward. The court inquired, who hired Mr. Hamilton? In short, North Georgia is the one who communicated and directed Hamilton in all of the revised plans and clarifications from the cities. If the court looks at Plaintiff's Exhibit 24, it's a series of emails between North Georgia and Hamilton regarding site plans for the subject property. Between March 27th through April 7th, this is the time frame where North Georgia worked with Hamilton to revise the plans. The emails show repeatedly Hamilton asking Mr. French for clarification so he can respond to the city comments. In response, Mr. French said, "Give me a call if you can, because I'd like to get this resubmitted ASAP." Mr. Beard is not included in that exchange in writing, and he testified he didn't confer with Mr. Hamilton. The emails show that Hamilton said, as of April 1st, "I still have several issues to resolve." April 7th, he said, "I still need a layout of the existing deck. The city is asking for this." And again, he said on April 7th, "I'm sorry, but this is taking so long as I know the house does not have the variations in size they are commenting on, and I'm trying to make the plan work with all the comments. It's so frustrating and complicated. I'm ready at this point to start from scratch." That was April 7th. Mr. French was the one in touch with Hamilton, and as of April 7th, Mr. French testified that he had completed the framing and even ordered custom-sized trusses. Yet the engineer's emails show there were too many deficiencies to cure and recommend, and he suggested starting over. So what framing was actually completed? What materials were ordered and charged to the Beards? And what were the dimensions if they weren't corrected through the engineer's plans? Rather, what plans were followed, if any? It's undisputed. There were no plans approved. Mr. French testified he worked with Hamilton to obtain these revised plans, but yet the engineer said it was easier to start over. But that never happened. To the extent the Beards are responsible for fees for the engineer, it shows there were no plans. There were no revised plans. Nothing happened, and yet we sit here with no permit and no finalized revised plans. Failure to obtain the permit alone constitutes a material breach and goes to the heart of the contract. A second failure was to address and correct repairs per the contract obligations. The first issue before the court is who breached the contract. North Georgia contends that my client's breach for non-payment of change order 1, change order 2, and the work allegedly performed in weeks 6 through 10. He seeks plaintiff, the entity seeks $93,000. Change order 1 included $30,666. Change order 2, $10,186. The balance on invoice 10 for weeks 6 through 10 is $52,195. The contract stated 3 times, all change orders must be executed by the parties. None of the change orders were approved. Section 5B of the contract states there will be no exception to the written requirement of written executed change orders. As a whole, the court should exclude the change orders from consideration as they were not agreed to by the parties and they were not executed. To the extent the court is inclined to review the substantive work listed, plaintiff testified some of the work in change orders was not provided. Yet that amount is comprised in his lien, the lien recorded in the deed records. Plaintiff testified and even presented of a demonstrative exhibit admitting certain work was not provided. Mr. Beard testified to that some of the work in change order 1 was not provided. Running through the different line items, in line item 1 of change order 1, both Mr. French and Jim Tillman testified the work was not completed. In line item 2, Mr. French testified he overlooked this existing site condition when he drafted the fixed price contract. Line item 3 of change order 1 related to an existing on-site condition. If you go down through the additional line items, not to belabor this issue, there was evidence that line item 8, the jack up, there was exterior rim work that needed to be completed. Line item 9 was a framing component. Line item 10, another framing component. Line items 11, 12, 13, 14, and 15, Mr. Tillman testified were not completed. And Mr. French even testified that line items 11, 12, and 13 were not done. At the end of the day, Mr. Tillman testified that about $14,774 of change order 1 was not provided. There's also credit to the Beards to be taken into account on that change order, $4,951. In summary, change order 1 should not be included because it was unexecuted. It includes work never provided to the resident. It includes credits to the Beards. And there is no claim in the complaint for unjust enrichment. The evidence shows that North Georgia breached the contract first in its complete failure to obtain a permit, build in a workmanlike manner, and failed to correct the issues such that change order 1 should be dismissed. As to change order 2, it's undisputed it was not executed by the Beards and should be dismissed too. To the extent you look at the charges, it includes calculation for interest allegedly owed. It includes a charge for tarps that he had already invoiced for Exhibit 10, and there's been testimony of no new tarps by Mr. French when he abandoned the job in May. He demobilized in the tech show. He left the tarps as is. The other fee is a lien filing fee. The $4,500 charge for his wife's alleged assistance in an insurance claim. There was no evidence she performed the work or provided her work product, and her scope of work was not part of the contract. The last 2 parts of change order 2 have moving fees for items from the basement to the garage and items to a storage unit. Mr. French testified he volunteered to help assist my clients in that move, but yet now he's coming back and seeking redress. None of these fees should be assessed. As to the alleged balance owed for invoice 10 for work performed between weeks 6 and 10, let's break down the numbers. The focus of this part of my closing argument is focused just on plaintiff's exhibit 25, any work allegedly sought for weeks 7 through 10. We show this alleged work was padded to an invoice to escalate amounts owed. This includes plaintiff billing for time for work not performed, billing for materials not provided, inflated quantities in labor, and demands for payment stages of work not yet completed. If you look at the progression of invoices from 1 through 5, it's undisputed my clients paid $210,819 for weeks 1 through 5. Week 6 starts at or near Mr. French's return from spring break on April 10th. No substantive work occurred from his return until his demobilization in May 16th. Mr. French was adamant he did not retrieve his equipment until June, and yet testified he continued to work at the property. Yet despite this statement, his deposition testimony confirmed his inconsistent statement where he did remove the equipment and abandon the job site on May 16th. How is it possible he continued to charge the Beards for work thereafter? Looking at the first entry for weeks 6 through 10 is a line item, plan review and permitting. The clients paid weeks 1 through 5, $10,800 for permitting work done. Plaintiff is suing for the balance of that budget allowance, an additional $10,700. Plaintiff is suing for this $10,700 despite his failure to obtain an approved permit. So of the $52,000 allegedly owed on invoice 10, $10,700 should be deducted because no more permitting work had completed. There was no permit. The second entry is equipment charges. Equipment charges for weeks 7 through 10 for a time when he was off the job. He's seeking $3,000. This is for equipment he owns. Clients paid him for weeks 1 through 5, $6,000 in rental of his equipment. So of the $52,000 sought, this value should be reduced by $3,000 for weeks 6 through 10. When you look at the next line item for framing labor, there's a charge for week 9 of $3,500. No work was performed in framing after week 5. As up to that point, the homeowners paid him $20,700 for framing labor weeks 1 through 5. Undisputed testimony shows that the framing was incomplete on the first floor in the basement. Now he's seeking $3,500 for week 9, which is the work week of May the 20th, 3 days after he demobilized his equipment. Of the $52,000 sought of this value, it should be reduced by $3,500. Dumpster fees. Weeks 1 through 5, the clients paid $9,500. Yet plaintiff seeks $2,000 now for weeks 6 through 9. Of the $52,000, this value should be reduced for that $2,000 charge for weeks 6 through 9. There's a charge for HVAC demo work of $1,500 in week 9, May 20th. He was off the job. There's another line item, temporary conditions on the roof. Clients paid $3,250 for weeks 1 through 5. Then weeks 6 through 10, the contractor charged an additional $2,660, but for what work? His text message in May indicated the tarps were leaking on the day he abandoned the job. He didn't add more temporary conditions, yet charged my clients an additional $2,660. That amount should come off the $52,000. There's a charge for exterior doors of $12,000, yet the testimony showed in change order 1 showed my clients are owed a credit of $4,951. That charge or credit should be subtracted from the $52,000. Wood deck repairs. My clients paid $8,200 for weeks 1 through 5 for minimal deck boards that were improperly fastened. Then plaintiff tacks on $5,100 for weeks 6 through 10 for no work completed as he had already demobilized. This $5,100 should be deducted from the $52,000. Plaintiff charged on week 7, $2,500 for Lindsay's help with an insurance claim. No evidence was provided of any photos or insurance correspondence or work product that she did, and these services were not included in the contract. The $2,500 should be deducted from the $52,000. If you deduct out the $10,700 for plan review, $3,000 dumpster rental, $3,500 framing, $2,000 dumpster, $1,600 for windows turnkey, $1,500 for HVAC demo, $2,260 for temporary roof conditions. Add in credit for the $4,950, credit for deck wood repairs of less out $5,100 for the deck, and Lindsay's charges. The total remaining of that $52,000 comes to $15,349. Yet, given the issues at hand, if this work was done, was it done to a level of properly being installed, or does it need correction? What's interesting is plaintiff even produced documents that he overcharged my client. In an effort to correct his own line items, he introduced demonstrative exhibits. At no point before trial did he ever take steps to amend or correct his lien. So the question becomes, if this work was it done correctly? Was it done per plans? Was it done per code? That's the central issue in my client's claim for negligence. First issue was whether or not there was a breach. And we've already shown plaintiff breached by no permit, no offer to repair the defective work, and failing to provide workmanlike conduct. As to their claim for negligence, Mr. Tillman testified that structural work was performed without approved plans, and some of this work was installed incorrectly. For example, Mr. Cordell, the plaintiff's expert, testified that the basement framing was incomplete. North Georgia testified that the framing was complete on the first level, yet 2 witnesses testified it was incomplete and needed repairs. Mr. Cordell testified in his own report that the first level was incomplete. Specifically, items 4, 5, 6, and 7 of his report showed framing code compliancy issues to be remediated. Mr. Tillman identified multiple framing work on the first level that he saw was incomplete, such as headers and blocking around the sunroom windows. Mr. Cordell too agreed with Mr. Tillman that jack studs needed to be added to the sunroom framing. The issue as to whether there's even adequate space in the existing framing to install the additional jack stud is still at issue. Mr. Tillman also showed or presented Exhibit 75, showing overlays of the first floor, showing incomplete framing, areas to be removed, and require fixing. The evidence was very undisputed that the windows as installed were not consistent with the express terms of the contract. The contract required double hung. There's no dispute that single hung was installed. What is in dispute is the value for this inconsistency. The windows as installed in close proximity to the sunroom door do not meet code and must be either tempered, or the Beards must purchase plantation shutters to remediate this discrepancy. Installation of the sunroom windows requires removing siding, removing the windows and patio doors, and possibly purchase new windows once the walls are reframed in order for the windows to set back in. It was undisputed the master bedroom had an egress compliance issue. There's disputed testimony as to whether or not the area needs to be reframed for the window openings for proper egress. The exterior doors also showed installation issues. The sunroom doors show there's been water intrusion. The evidence showed while it may have been a byproduct of the roof tarping, there was also flashing questions as to whether or not it was installed and sealed properly. The testimony showed the doors were just set. There was no evidence that they were sealed or flashed. The deck repairs were minimal, not properly fastened, and no rail installed, and the work must be redone. Mr. Cordell ended his testimony and said that no inspector would have approved the work as performed. Looking at Exhibit 73, Mr. Tillman copied information from Invoice 10, the alleged percentage of work provided, and quantified what actual work he felt was completed based on his on-site inspection. He assessed the value of the work against the budgeted amount. This created an issue in dispute. He quantified that the percentage of work provided on site at the property by North Georgia, taking into account North Georgia's alleged value, that North Georgia provided $304,000 worth of work. His Exhibit 3 showed that North Georgia overcharged the Beards $187,608.27. The converse of that number means that if North Georgia charged $304,000 for material and labor, the court should subtract the amount of the overage, the $187,000, to get a difference of $116,522. That value $116,522 would be the value of alleged work performed by North Georgia and its equated value. To the extent North Georgia only provided work in the amount of $116,522, the Beards overpaid North Georgia. They paid $210,819. If you take these two figures, the amount the Beards paid less the value of work provided by North Georgia, there's a difference of the Beards overpaying by $94,296.27. In addition to overpaying North Georgia by this $94,296.27, they must also remediate some of the work. Mr. Tillman estimated in Defense Exhibit 76, the cost to rework some of that work was $20,800. Furthermore, the contractor's breaches had real consequences. Because the framing was improper and unpermitted, the plaintiff's insurance or third-party inspection withheld insurance claim proceeds. Because the house was uninhabitable due to the fallen tree and the contractor's improper structural work, the homeowner incurred rental expenses and ultimately purchased another home. These are foreseeable consequential damages flowing directly from the plaintiff's breach. Judy Beard testified that after insurance proceeds reimbursed her for 1 year of living costs from April 1st, 2023 through March 31st, 2024, she incurred the following amounts. Rental charges at $4,500 a month for April of 2024 through December 31st, 2024, 9 months totaling $40,500. She also testified she purchased a new home in December of 2024. Her mortgage payments of $3,800 began February of 2025. February through trial is 11 months. 11 months at $3,800 is $41,800. In summary, the Beards show the following damages. The cost to repair their work in the amount of $20,800. The amount they overpaid plaintiff, $94,296.27. Damages for their unreturned chairs of $10,000. The refrigerator of $3,200. Windows from the front elevation that were removed and installed with less than same quality windows of $5,000. Living cost for 9 months at the rental of $40,500. Living cost at their new house for 11 months at $41,800. Well over $200,000 in damages. Both sides have claims for breach of contract. North Georgia claims $93,000, which includes $40,000 of 2 unsigned change orders. As to their remaining balance of $52,000, the evidence shows the work was not provided, the work was incomplete, the work was unacceptable, the work was never corrected. The evidence shows North Georgia breached the contract first. 1, failing to obtain a permit. 2, failing to provide a written notice of default. 3, failing to provide the work, material, and services in the invoices presented such that the inspections failed, precluding the release of the insurance escrowed funds. 4, failing to provide workmanlike code compliant work. 5, failing to repair the work that was performed as required and necessitated by the contract. 6, failing to provide the warranty as listed in the contract.
Ms. Rose, let me stop you. Let me stop you for a minute. What evidence was there that the Beards ever demanded a repair or whatever the word would be, remediation or whatever of the work that had already been done?
In plaintiff's complaint, was a copy of their Right to Repair Act demand letter.
Okay, thank you.
Mhm.
And did that
The
have
bear-
an amount in it?
The complaint had the right to repair along with Mr. Tillman's report. Exhibit. It had the items it had the items listed, not a dollar amount, but it had the items listed of what
Okay.
there were issues of concern.
Okay, and when you're saying in the complaint, do you mean North Georgia's complaint or your counterclaim?
In the counterclaim is an actual copy of the Right to Repair Act notice
Okay.
with Mr. Tillman's report and the
Okay.
issues to be addressed.
Thank you.
The Beards here never refused to pay. Rather, their insurance funds were not released due to plaintiff's work as listed in an invoice submitted as a draw was not apparent to during the on-site inspection in inspections 2 and 3 by Safeguard Properties.
Well, do you acknowledge, and let's take the quality of the work out hypothetically. Do you acknowledge that to the extent, for example, adding a second floor, that when the insurance company came to inspect and there was clearly work associated with the renovation, that the insurance company would take the position, well, hey, that's on you. We're not responsible for that. Do you think that was valid? That the insurance company would say, well, that's not us.
That wasn't part of the insurance inspection. The inspection in the documents, the 84 page documents from Safeguard, the inspection was called in or triggered upon a draw request. And the draw request came from North Georgia's invoices of work done to get the house ready or the work done. And so the on-site inspection was assessing of the work that was allegedly done with the framing in the basement, with the framing on the first floor. This wasn't second floor framing yet. The inspection was to detail the on-site conditions if it matched the invoices submitted in the draw request. So this is not the insurance was not paying or releasing funds for a second story renovation. What the record doesn't have the underlying invoices and dimensions of the work the insurance was approving. The inspection was clearly based on, we have a draw request submission that came from North Georgia's invoices for that week of what work it was done. The inspection was evaluating per the draw request received, plaintiff's invoice, is that work apparent and was it done on the property? That's the inquiry, not whether or not it's related to a second story install. Did that answer your question, Your Honor?
Sort of. I mean, let's take the front windows that
Okay.
were so controversial. I don't know, but a tree falling in the back of the house may not have impacted the front windows. I guess all I'm asking is there, and I candidly haven't read through them yet, but could the insurance company have very validly turned down a request because it didn't relate to tree repair?
No, excuse me, if you look through Safeguard's exhibits as I presented, their comments were the value of work requested in the invoice doesn't match the on-site conditions of work performed. So the inspector had a draw request, an invoice for work allegedly performed. And before the insurance will pay that draw amount, somebody independently, unrelated, verifies the existing work. Was that work in that draw request done? And so at a minimum, the first work that had to be done to the house was to restore the house from the fallen tree and get it, that was part of the immediacy. So the inspection is evaluating what work was invoiced and was that invoiced work actually completed at the property. And the notes and safeguards show the percentage of work is not equivalent with what we're seeing on the property, and that's why it was rejected. It would not have been for the inspector to deny it because it's a repair work for the second story. The second story was never constructed. This is just the initial, North Georgia was on the project for 5 weeks doing work. And so, yes, there's a lot to do to prep the house for these types of repairs. So that wasn't even, I think, a factor based on what was submitted in North Georgia's invoicing of what was done. I hope that further clarified your inquiry.
Sort of.
So, I'm almost done with my closing. I'm just jumping back. Result of all these breaches of contract, it's our position plaintiff breached the contract first. Had the money been released from the insurance proceeds in the second or third draw, payments would have been made, but yet there's no evidence that the contractor would have remediated or fixed the work. Instead, my client's damages continue to accrue. Aside from the damages we've talked about, the lien, as recorded, and from Mr. French's own testimony, was never even reduced based on the work he admitted under oath was never performed. This lien has impacted my client's ability to move forward with the project. Contract damages can be awarded for these damages that arise naturally under the contract under OCGA 13-6-1, 13-6-2, and 13-6-7. Consequential damages are a result of the immediate fault or the immediate fruit of the contract. We're seeking the consequential damages of their inability to live and habitate the home and the carrying costs they had to pay after insurance under 13-6-8. These damages are all attributable under their claim for breach of contract for plaintiff's failure to follow the contract.
The contract duration, or can you hear me okay? I'm kind of
Yes,
back
ma'am.
from, okay.
Yeah,
The
sure. I'm hearing fine.
The contract duration was originally, I think, something like 9 months.
Correct.
So they had planned to be out of the house for 9 months, right?
Correct.
Is that
And they were
accounted
not-
for?
the first 9 months or year they were displaced from the house. The testimony showed insurance paid for those costs.
That was the
We're-
150,000 for moving expense. There was testimony, there was 150,000 sort of upfront payment, which I understood was for moving personal property, perhaps,
Yes,
and then someplace to live.
correct. We're not seeking duplicative amounts. We're only seeking after that year that insurance covered. That's April of 2024, those 9 months, plus the purchase of their house in 2025. So we're not seeking any duplicative fees that they had reimbursed from insurance. So the 9 month in the rental of $40,500 is after insurance stopped paying, and the 11th months at the new house is thereafter. Defendants also counterclaimed under OCGA 51-1-2 et al. For negligence. There was a breach here of the legal duty with resulting damages to my client. Under the Right to Repair Act, as contemplated in the contract, and the contractual requirements to provide work free of defect and in accordance with industry standards, the evidence shows that the work would not and could not pass inspection. The contractor's work was inconsistent with the scope and specifications called for in the written contract, and plaintiff failed to redress the work. The company now seeks payment not only for the work that was improperly executed, but for work that will have to be redone. This is negligence and a breach of contract. It destroys the benefit of the bargain and forced the homeowners to incur repair and completion costs to correct the very work plaintiff claims to be owed for. North Georgia cannot recover for work North Georgia cannot recover for work that was never done or recover for work that must be redone at its own fault. These amounts are recoverable offsets against any award on plaintiff's claim, but yet separately support a counterclaim for breach of contract, breach of warranty, and negligence. Contract law is clear. One who breaches a contract cannot sue a party for failing to pay where there were their own breaches. We think plaintiff breached the contract first. For these reasons, we ask the court the following. 1, enter judgment in favor of the defendants on plaintiff's claim of breach of contract and award no money to the plaintiff. 2, order the lien stricken from the record. 3, enter judgment against the defendant on their counterclaims for breach of contract and negligence. Award the defendant damages for the cost to repair and complete the work, damages for overcharges and unearned payments, consequential rental damages and the mortgage payments, and any other recovery the court finds in favor of my clients. To the extent the court grants a breach of contract or negligence claim, the plaintiff sued for a claim for attorney's fees under 13-6-11. To the extent now is the appropriate time to proffer attorney's fees, I'm happy to do this now or bifurcate that at the court's direction.
I would like you to go ahead and do it now.
Thank you.
This will be in the nature of hitting a provisional.
Understood, Your Honor.
And then,
I
of
have
course,
been
I'm going to allow Mr. Gowans to cross-examine you.
Absolutely. And he has a copy of the fees. I have been practicing real estate.
Do I have a copy of the fees?
No, good point, Your Honor. I apologize. Do you want me to email them right now?
Yes, please.
Okay.
I'm not going to be looking at them right now, but if you will email them to me, I'd appreciate it.
Do you want them right now or wait till he starts his closing? I just want to be
Well, you can send them right now, but I'm not going to review them right now.
understood. And I'm copying of Logan Council. Okay. I have been practicing real estate litigation since 2003 for over 23 years. My hourly rate is $400 per hour, which is a reasonable rate for my experience in the Atlanta metro area. My associate, too, has been practicing for 15 years, and she has been billed out at the rate of $350 an hour. The work that we're requesting as part of the attorney's fees includes the realms limited to filing the answer and counterclaim, preparing written discovery requests, answering discovery requests, the taking of a deposition, followed by trial prep. I have sent opposing counsel in the court redacted billing report and activities report prepared by Rose Litigation. In reviewing the time associated with these tasks, the time spent to prepare the answer and counterclaim was $1,760. The time spent drafting discovery requests to opposing plaintiff was $1,765. The
What was
time,
that? What was the 1765 for?
drafting discovery requests to the
Okay.
plaintiff,
Okay.
drafting discovery responses on behalf of the Beards came out to $5,910, as there was discovery served on each of them individually. The time for taking the corporate deposition and preparing for that was $4,600. There was a $493 expense for the corporate defendant's no-show at the first notice deposition. The court reporter time for the corporate deposition was $3,521.18.
Did that include getting the transcript?
Yes, ma'am.
Okay.
Trial prep, $13,440.
13,000 what?
$440.
Okay.
I have the dates of the work to support this. I just didn't want to take up too much time, but I'm happy to identify those as needed or during cross. I would, in conclusion, Your Honor, show that a claim for bad faith, there's a case similar to our case when here by contract, a builder is required to fix defects, work issues, yet a builder is forcing payments as a prerequisite to performing the repairs that builder was already obligated to perform, would necessitate the bad faith requirement under 13,611. And in support of that bad faith, I would defer the court to Ryland Group versus Dally, site 245, Georgia App 496 at year 2000. And we would ask the court to award those fees as additional damages.
You
Thank
want to
you, Your
add
Honor.
all that up for me?
I will. I'm just going to double check my math real quick, Your Honor. Do it one more time.
I can do it. I can do it.
I think I have it. I'm almost. 5, 9. Okay. Yeah, I came up with two different. I think the number is 31,489.88.
Okay. Okay, now before, I'm going to let Mr. Gowans cross-examine you. Well, go ahead now, Mr. Gowans, if you have any questions on our fees.
I just have one question. Ms. Rose, isn't it true the first deposition was scheduled with you without my confirmation?
It was, there were several email exchanges where I gave proposed dates, and I believe at the time it was noticed you were out of town despite attempts to try and reach you and coordinate, which is why we just agreed to reschedule it. However, we did incur cost because of that.
And the date that you chose was the time that I had filed a leave of absence?
I don't recall if that's the case, but I do recall multiple emails trying to schedule it within a date and within the time frame of our scheduling order.
So if I had filed a leave of absence during that time, you would agree there should not be any liability for payment of those fees, correct?
If it was filed during your leave of absence, I understand your position. There were though multiple emails unresponded or where we couldn't pick a date. So even extracting that $493 fee, the court reporter cost of $35.21 were paid. Although we both agree it may be high, it was a damage.
You're talking about 35, 31 for the time that
Yeah.
it was a no-show?
No. The no-show was just right under 500, 493. So I don't have the dates. If it was during your leave of absence, then, I will defer to your word on that.
I have no further questions for Ms. Rose, Your Honor.
Okay, Ms. Rose, I've got just some questions. And again, I think you brought up one of your answers to one of my earlier questions, I think was a very, very sound answer. And I should remind both sides to the extent I'm asking questions that were not part of the evidence, then just tell me. I may be just curious. And okay, so a major point of North Georgia Builders and via Mr. French's testimony was the owners were responsible for the plans. And if I heard that once, I almost heard it as many times as I heard spring break and bounced check. So over and over and over, there was that the owners were responsible for the plans. I looked through the contract and who was responsible for the plans, according to your client?
Your Honor, I appreciate that question. The contract was drafted with my client's first set of plans. You can see in scope A where it says the construction estimate is per the drawings from Unique Homes and Design. My clients provided that. Those are the plans that the testimony showed that North Georgia applied for the permit with those plans and they were rejected.
Okay.
It was thereafter, Mr. Hamilton came in and the evidence showed all of his communications were with North Georgia. I think there was also evidence that my clients did pay Inspection Wizards or Mr. Hamilton a bill. But the way I read the contract is my clients did supply plans at the beginning, and that's what the plaintiff utilized to build out this budget, to build out a fixed price contract. So in one part, my clients did provide plans. There were modifications to the scope of those plans in the contract, and that's what the stipulation is, where this scope of work is superseded by the drawings. But when the plans as submitted, the Unique Homes were denied and rejected, plaintiff had the obligation as a licensed contractor to facilitate getting updated plans, analyzing the comments with the engineer. My client was removed from that. And if there was an issue, the GC, the licensed GC, could have stopped everything. And if it was on my client to call Mr. Hamilton and get these plans revised, he didn't stop the work.
Okay. So I'm back to the question that I asked last week, and your answer was, who hired Hamilton?
It's hard. I don't know that there was true evidence. The letters that were introduced show, I think, a Brandon Fogart, and I think he is the architect from Unique Home Designs, which were the initial plans submitted. So I don't know that there was evidence of how Unique transferred to Mr. Hamilton.
Either Mr. Beard or Ms. Beard, I think it was Mr. Beard, said very plainly from the stand under oath that North Georgia hired Hamilton.
And I thank you for refreshing my memory. If that's the case,
I don't know that hired is the right word. I don't want to infuse it with any meaning that North Georgia found Mr. Hamilton and had done work with him before.
And I would support that with Plaintiff's Exhibit 24. When you look at these 4 pages of emails, it is directly between Mr. French and Mr. Hamilton.
I get that. I'm just, who brought Hamilton in? Maybe that's a better question. And I think your face says just not part of the evidence.
Or if my client testified it was North Georgia, I would stand behind that.
Okay. Now, do you agree there's a contract here?
Yes, there is a contract.
Okay. Now, I suspect Mr. Gowans is getting ready to tell me a lot of times that there's no attorney's fees authorized in the contract.
Yes, I would agree. There's no attorney fee provision.
So we're just traveling on consequential damages. Was 13-611, is that bad faith?
13-611 is bad faith in having, not bad faith in the litigation, but for the underlying facts arising, necessitating the litigation.
Then
And so, Your Honor,
how come plaintiff can't ask for them?
Plaintiff did not introduce evidence before he rested that North Georgia incurred attorney's fees.
Okay. Okay, wait a minute. Where is your office, Ms. Rose?
Physical office is in East Cobb. You want the address?
Please.
533 Johnson Ferry Road. Building D.
Wait. Johnson Ferry Road.
Sorry.
Okay.
533 Johnson Ferry Road. Building D as in David. Suite 400. Marietta 30068.
Okay. Now, I could have gotten that from the record, so that's, I just was asking as a matter of convenience. All right. I think. Okay, I think that's all my questions. I can't promise, but ready, Mr. Gowans?
Yes, Your Honor, just give me 1 second.
Okay.
Can you hear me okay, Your Honor?
I can.
Okay, first, I just want to clarify something that came up from the beginning. The total amount paid by the Beards to North Georgia, it's actually on the exhibit. I believe it's P25. It's $210,000 and some change. So any money that had been paid to the Beards from insurance draw would have been directly to them and would not be a part of this dispute from the perspective of monies paid. So basically, this project was a major rebuild of the Beards' home, precipitated by a large tree falling on their house, a house built over 50 years ago. Thankfully, no one was injured by the fallen tree, and I do say that sincerely. It sounds like just by God's will, Miss Beard was not crushed by that tree. Belatedly, the Beards took this opportunity to dramatically enhance their home by adding a second floor and finishing the basement. This project, if it is ever completed, will triple the square footage of the home. The original cost of the project was $773,000. Now, when I say belatedly, the tree fell in April 2023, and North Georgia didn't get on this job until 2024. So any money that they got paid for living expenses was consumed long before or about the same time that they started the project. But due to the insurance claim, which Mr. Beard testified exceeds $400,000, this project requires two sources of funds to complete. $400,000 plus from the insurance, with the remainder coming from the Beards. The insurance funds are held in escrow to be dispersed only as to portions of the insurance claim are completed. And that's going to be standard operating practice. No insurance company is going to pay for work that's got nothing to do with the claim. Moreover, the plans that the Beards provided to North Georgia were not just inadequate, they were unusable in the form they provided. Among the many issues, the dimensions were wrong, and they did not provide details to ensure sufficient support for the second floor. Plaintiff's Exhibit 4 details the initial issues the city had with the plans. Mr. French, Mr. Cordell, and Mr. Tillman all agree. The quantity of comments from Brenda Page, the person in charge of issuing the permit, is excessive. North Georgia did not create this problem. Rather, this is the result of the plans provided by the Beards. Bill Hamilton, the project's engineer, made extensive revisions to get the Beards' plans approved. As evidenced by D22, page 511, on May 17, 2024, the plans were close to approval. Again, you've seen P4. There's a lot of things included in there, and to get them down to just a few minor little issues, that took a lot of work. At trial, as was just previously stated, Mr. Beard testified that North Georgia was responsible for hiring Mr. Hamilton. Like most of his claims, Mr. Beard did not provide any corroborative evidence to support this claim. In contrast, P15 is correspondence from Mr. Hamilton dated November 1st, 2023, and addressed to Brendan Froggett from the House of Charles. The Beard's first contractor has nothing to do with design or anything like that. This is the company that came out and did some of the initial work and did some of the initial framing or temporary framing for the roofing so we could have the tarps. P23 is correspondence from Mr. Hamilton addressed directly to Mr. Beard. Thus, the only evidence that Mr. Hamilton was retained by Mr. French was Mr. Beard's testimony. And this is testimony from a party who claims he had an approval for a $900,000 loan when his application was only for $706,000.
Okay, so you're claiming that Mr. Hamilton came into the picture through House of Charles.
It originally would be through House of Charles or through Mr. Beard, but that was the original interaction of Mr. Hamilton on this project was when House of Charles was on the project. Now, who actually hired them? I can't say for sure, but it certainly was not, and as Mr. French testified, it was not North Georgia.
Okay.
At best, Mr. Beard's memory during his testimony was selective, considering Mr. Hamilton was working on the project for 4 to 5 months before Mr. French was retained and subsequent reports were addressed directly to Mr. Beard. There's no doubt Mr. Hamilton was originally brought to this project by, if not by Mr. Beard, by a previous contract hired by Mr. Beard. But even if Mr. French hired Mr. Hamilton, it does not change the facts in this case. As Mr. French testified, Mr. Hamilton has extensive dealings with Brenda Page, who's the person who's in charge of signing or issuing the building permit. And that extensive interactions and experience with Ms. Page could only assist in getting the building permit. Change order number 1 reflects Mr. Hamilton's revisions. It also includes work to correct framing issues caused by the Beard's previous contractor in 2022. Apparently, the Beards did $250,000 in renovations in the months before the tree fell. all without a building permit. At one of the weekly meetings, Mr. French explained to the Beards each of the items on change order 1. Before the work commenced, North Georgia provided change order 1 to the Beards for their approval. They did not reject the change order or question the items on the change order. They just ignored Mr. French's request for them to sign off on change order number 1. Yet they kept insisting the work continue and kept promising to pay. To his regret, Mr. French stayed on the job and kept doing work, all because the Beards repeated promises to pay. These promises are reflected in their emails and text messages to Mr. French, as evidenced by D22. Never once did they complain about the quality of North Georgia's work or question what was completed relative to invoices. Further, P13 reflects the Beards reported to the insurance inspector that they were satisfied with the North Georgia's work. Additionally, P29, Ms. Beard states that they are happy with his work. Until the end, the Beards made multiple efforts to persuade North Georgia to return to the project and continue work. These are not the actions of dissatisfied customers. P29 provides true insight into the real issue behind this dispute. The Beards could not get financing to fund this portion of the project. Of course, at trial, the Beards tell a very different story. Related to money, Mr. Beard's testimony was all over the map and inconsistent with any corroborative evidence. Mr. Beard simply could not keep his own story straight. He argues the project should not have started until a building permit was issued. Then he complained that work may have been ordered to stop because it was taking a long time to get the building permit. Mr. Beard even denied the 2022 project was completed without a building permit, despite his own email correspondence about Brenda Page to his city councilwoman complaining about delaying the issue of the building permit. Mr. Beard played ignorant as to the building permit process, despite being a residential real estate developer by profession. Then he testified he never pressured North Georgia to begin work before the building permit was issued. In fact, he testified he was leery of the work commencing before the building permit was issued. Yet, as evidenced by P22, the first contract to the parties entered into was $70,000 less than the final contract. As Mr. French testified, this was because work had commenced and Mr. Beard wanted a clean contract without any change orders to present to potential lenders. Notwithstanding, Mr. Beard testified that he preferred to pay for their portion of the project with their own savings to avoid incurring interest from the construction loan. Oh, and he was also approved for a $900,000 loan. And he testified he needed a $900,000 loan to pay off the existing loan and to cover the cost of the project. Only he could not close on the loan because of North Georgia lien. Never mind, the lien wasn't filed until the end of June, months after this loan would have closed. Moreover, Mr. Beard's testimony on this regard doesn't even make sense. The amount owed on their current loan is about $300,000. Thus, after paying off the loan, there would be $600,000 left over. That is not enough for the total project and is $200,000 more than the remaining portion of the project. Also, $900,000 is $200,000 more than his loan application, which reflected the exact amount of the initial project of $706,000 and some change. In response, Mr. Beard could not remember the loan amount, despite confidently testifying to the $900,000 amount and the reasons for this amount just a few minutes before. The Beards also believe that North Georgia should be responsible for all their living costs since April 24, despite delaying a year to start the project, when the insurance was covering their housing expenses, and not taking any actions to complete this project since June of 2024. They did absolutely nothing to mitigate their damages. Now, the building permit, this was a big part of what happened in the trial. And the lack of a building permit was an obstacle impeding the completion of the project. As Mr. Corder testified, it is not a problem provided nothing is covered up, and North Georgia only completed work up to a point. Upon his inspection of the work, except for tempered glass in 2 areas, all the work completed was pursuant to current building codes. Moreover, adding a clear film to the glass inexpensively and easily resolves this issue. Further, and completely unnoticeable. Further, work was only completed to the point Sandy Springs could complete its inspections and issue a building permit. Items such as doors were installed, but external framing and hardware were not installed. These items were not built. Mr. Cordell also testified that the windows in the sunroom were installed correctly and that the second jack studs needed to be installed when the walls were tied together with the second floor. Mr. Cordell testified the water damage at the door was caused by degraded temporary tarping. By the way, this is the same tarping that Mr. Beard testified he has a crew go out every few months to check and replace the tarping. Both Mr. French and Mr. Cordell testified the tarping was severely damaged. Further, as evidenced by P35 and P36, the tarping in its current state provides no protection to the home. Maybe it keeps a few leaves out, but that's about it. It certainly is not keeping anything dry. While Mr. Tigman testified there are items he would have done differently, he is not approved as an expert on building codes, and he did not identify any code violations other than the tempered glass. Further, Mr. Tigman made a bid to complete this project in excess of $800,000 and testified he anticipated getting the contract once this matter is resolved. True to form, the Beards claim Mr. Tillman's belief that he would be contracted for this project is misguided. Promises don't mean much to the Beards, only their interest. In any event, there's no evidence that the work completed does not conform to the current building codes. Thus, the Beards' counterclaims for both count 1 and count 3 must be denied. Now, regarding overbilling, if Mr. Tillman is believed claims everything North Georgia did would have to be redone. Mr. Tillman's testimony must be taken with a grain of salt. First, his assessment contradicts inspections showing the portion of the project related to the fallen tree was 35% complete. Second, Mr. Tillman is not qualified to evaluate the construction completed. All he can testify to is how he would have done it. He cannot testify if what was done is wrong. By way of example, Mr. Cordell testified the back deck and stairs need to be completely rebuilt. Mr. Cordell testified this assessment is in alignment with Bill Hamilton, the structural engineer. Per Mr. Tillman, the deck is fine with the repairs Mr. French completed, except for the screws that are not installed. Mr. Tillman did not even notice the reasons the screws were not installed, which is the deck had to be anchored to the chimney. Further, he never contemplated the warping to the deck repair likely occurred after North Georgia left the job for non-payment before it could complete the task. But even in his own exhibit, D76, he omits the need to jack up the sunroom. Finally, Mr. Tillman had never seen P4 or had ever worked on a project with so many deficiencies in the renderings. He also acknowledged he has no idea the amount of time or effort Mr. French had to complete to get the plans approved by the city. Yet, he claims the work to get the building permit approved should never cost more than $2,000. Of course, this testimony followed his own testimony that all he had ever do to get a building permit was to submit plans and correct 1 or 2 minor issues. That is not what we were dealing with on this case as P4 evidences. Finally, Mr. Tillman believed, and he still believes, he's getting an $800,000 contract. Naturally, he's willing to do anything that he can do to help out his clients. Of course, any money awarded to the Beards, from his perspective, would be available to fund his work on the project. Clearly, Mr. Tillman provided reports that 1, he is not qualified to prepare, and 2, that were given to protect his own interest in the project. Arguably, his testimony might be different if he knew the truth. the Beards had no intention of completing this project. In any event, count 2 of the Beards counterclaim also fails. Let's talk about the insurance funding. When it comes to understanding the alleged failed insurance inspections, Ms. Beard likely did not understand what was really happening. However, there's no doubt Mr. Beard did. On both of the directs, the Beards testified about failed insurance inspections. These alleged failed inspections are not failed inspections, meaning the insurance inspector did not disapprove any of the work completed. Rather, the inspector did not approve releasing additional funds from escrow to pay North Georgia. All of these requests were made by Mr. Beard. In D71, which was request, Mr. Beard claimed the project was 50% complete in hopes of getting $200,000 released from escrow. Keep in mind, the insurance was only responsible for repairs related to the fallen tree and not the overall renovation project, i.e. shoring up the basement supports, trenching for 2 new bathrooms in the basins, repairing framing from previous contractor, etc. Even with this consideration, the work related to the fallen tree was deemed to be 35% complete, which equates to no less than $140,000. It's impossible to say for sure, as Mr. Beard did not provide any evidence showing the amount of his insurance claim. He merely stated it was in excess of $400,000. So up to this point, most of the work completed had very little to do with the insurance claim, because the big part of the insurance claim is the roof, and you can't really do the roof until you build the second floor. Mr. Beard understood the situation. He just didn't like the result. No more money from the insurance company until the project progressed. In short, the Beards wanted the insurance to pay for renovations beyond the scope of work related to the fallen tree and blamed North Georgia for the insurance rejection of these requests. But the sourcing of funds is not the responsibility of North Georgia. Further, the Beards' misguided efforts evidence the financial strain this project imposed on the Beards because they could not get financing. The real reason for the inability to get financing, as Mr. Beard told Mr. French, was liens against them in South Carolina, which had nothing to do with this project. Simply, the Beards did not qualify for the loans. In their correspondence with North Georgia, the Beards repeatedly plead with Mr. French to give them more time to get funding. At trial, they claimed they could have just paid for the project out of pocket. In fact, Mr. Beard testified he preferred this option to avoid interest charges. Now, it is North Georgia's lien that prevents them from getting financing. Yet, Mr. Beard presented no evidence to corroborate his self-serving testimony. He claims to have a pre-approval from Bank of America, but he admits he never produced a discovery, or more importantly, never provided to Mr. French while they were still begging him to finish the job. Additionally, they never produced any evidence to corroborate the reason this elusive loan was rescinded or the reason a Bank of America would not accept a surety bond. Why not? The reason is simple. This phantom loan never existed. There was never an approved loan from Bank of America or any other lender. Even more curious, the Beards never just paid for the project out of pocket, which Mr. Beard testified he preferred. This option was available to them from the very beginning. After North Georgia walked off the job, hiring a new contractor and completing the project became even more important. First, the Beards had a duty to mitigate their damages. By completing the project, the home would not be subjected to the elements for another year and a half. Arguably, the project would have been completed before they moved into their new home, if not before, then soon thereafter. Second, if they had finished the project, it would be easier to prove their counterclaims and support their alleged damages, instead of relying on the contractor they led believe was getting the job. Instead, they did nothing, except promise Mr. Tubman an $800,000 contract. In fact, nothing the Beards did makes any sense unless the Beards' real motivation is considered. Their home is located in a highly desired location. In 1975, when this home was built, the neighborhood was a modest middle-class neighborhood. Today, it's transformed into an affluent neighborhood. fact, Mr. Beard testified he could sell the property as is for a considerable sum. This is one of the few true statements from Mr. Beard. As is the trend in Sandy Springs, these modest homes are demolished and multi-million dollar homes are built on the sites. Thus, any purchaser of the property as is not going to care about the current condition of the house. They'll knock the house down anyway and build their dream home. During the same line of testimony, Mr. Beard let slip that their intent was to sell the home after the renovations. This also makes sense. An older couple without any minor children in the home does not need a 6,000 square foot multi-level home. However, such a home would be very desirable in the Atlanta market. After insurance paid for the half of the renovations, the Beards would only have about $400,000 invested in the property, with $300,000 left on the mortgage. The home, once renovated, would be worth substantially more than the Beard's investment. Again, Mr. Beard is a real estate investor and understands this project was worth a lot of money. This also explains the reason they did not want to use their own money for the project, either before they hired North Georgia or after North Georgia walked off the job. Further explains why they've done nothing to advance the project to protect the property. Finally, it explains why Mr. Tilghman will never get this project. This project will never get built. The current plan is to sell property as is, collect the insurance money, and hope for a nice award in this case. Now, other North Georgia damages. Ultimately, North Georgia wants to get paid for the work it completed. These items are set out on P25. However, during trial, North Georgia's claims were amended via Mr. French's testimony and recalculated through demonstrative exhibits P45 and P46. So if we look at invoices, rebate from invoices 1 through 10, Mr. French credits $8,488. The rebate from change order 1, $2,583. Rebate from change order 2, which was interest that was calculated, is $1,727, with a total rebate of $12,798. The original claim was $93,047. When you take away the rebate, the new total is $80,249. The contract interest is 18% APR, and it's been a year and 9 months, with a total interest charge of $23,978.41. The new total is $104,227.41. And that's the amount that North Georgia is seeking the judgment for. Now, pursuant to, talking about attorney's fees, pursuant to.
Before you get there,
Sure.
Mr. Gowans, let me just ask you a couple of questions.
Sure.
What is the legal basis for damages related to the change orders when they were not signed?
That would have to be either a quantum merit claim or that they had approved them by lack of any kind of negation of those change orders.
Now let's talk about quantum merit, since that was going to be one of my next questions. So if you're, is there a basis in the record for a claim of quantum merit, or are we going under a general premise that the evidence reconstitutes the pleadings?
I would say the evidence reconstitutes the pleadings, Your Honor.
Okay. Okay, now, what happens to the lien? The reading through your complaint again in preparation for today, are we foreclosing on the lien? Are we well, subsection of that question, what happens to the lien? And then we need to make sure, as a result of whatever happens here, that the lien is dissolved in the for argument's sake purposes only realm that your client wins damages, that instead then you would have a judgment lien instead of a materialman's lien. What happens to the lien? Because I want to make sure that Fulton County real estate records are kept clean.
Well, the promises that records in Fulton County real estate are going to be clean is, that's an issue for another day. But as far as this particular lien, if there's a judgment in favor of North Georgia, then that lien obviously would be canceled in lieu of the FIFA that would be entered showing the judgment. And I would say likewise, if there was a judgment against North Georgia, then that lien would also have to be canceled. So the ultimate result of this case is the materialman's lien would be canceled in respect to whichever way this court decides to award damages, if any damages are awarded at all. In other words, it would kind of merge in there together.
From a statutory standpoint, and I haven't looked at this, I mean, I come in contact with it a lot, but from a statutory standpoint, you know, I'm just trying to figure out, I mean, doesn't the statute say something like it shall be, it has to be filed, there has to be litigation within a year, and then is it foreclosed on like any other lien?
My understanding of it, Your Honor, is that the lien, the mechanics lien would be rolled into whatever
Okay,
the judgment is of the court, which would then be reduced to, you know, execution or a FIFA.
okay, okay. All
But
right, sorry, let me check my,
if it's, you know, if it please court, we can still cancel the mechanics lien just to clear the record. And that's, I think that's a simple procedure that can be taken care of.
okay, let me just, got that. Okay. Okay, I'm sorry, keep going.
Attorney's fees under 13.611. OCGA 13-611 holds that expensive litigations generally should not be allowed as part of damages, but where a plaintiff has specially pleaded and has made a prayer, therefore, and where the defendant has acted in bad faith, has been stubbornly litigious, or has caused plaintiff unnecessary trouble and expense, the jury may allow them. I look at Nash v. Studdard, which is 294 Georgia App 845, 670 SE 2D 508, 2008 case. Court of Appeals held recovery for stubborn litigiousness or causing unnecessary trouble and expense is only authorized if no bona fide controversy or dispute existed as to defendant's liability. And in that, it's citing, Nash is citing Weiland v. Murray, which is 292 Georgia App 30, 663 SC 2D 403, a 2008 case. Moreover, Nash also holds attorney's fees are not authorized under OCGA 13-611 if the evidence shows there is a genuine dispute exists, whether of law or fact, on liability or amount of damages or any comparative issue. That's also Nash citing M&H Construction Co., the North Fulton Development Corp. That's at 238 Georgia App 713, 519 SE 2D 287, and that's a 1999 case. There is no doubt this case had many genuine issues in dispute of both of fact, what was going on. And as a result, attorney's fees are not awardable under 13-611. Now, Ms. Rose cited a case, see my notes real quick, and it had to do with the contractor demanded payment before repair. And so in other words, if I haven't read the case, but the way she explained it was there was like a warranty or repair that was requested, and the contractor said, hey, wait, before I go do this repair, you got to pay me for something. I don't know if it was for a past due bill or for the repair itself. But that's not what happened here. in this particular case, despite the Beards claiming all these defects, North Georgia denies any of those defects. So they weren't demanding payment before repairs. They were demanding payment for work that was completed. And that's a very different situation. I think easily distinguishes between the case cited by Ms. Rose. Finally, in regard to the Beards, chairs, and allegations of stolen tools and abandoned refrigerator, etc., these claims were never raised in the pleadings. Thus, these claims are waived. Notwithstanding, the Beards are free to collect their chairs from North Georgia. Due to the current relationship between the parties, it would be best if they send a third party to collect their chairs. And this was actually offered to them during the litigation, and which Ms. Beard confirmed. In regard to the stolen tools, Mr. French does not have these tools. Moreover, Mr. Beard did not provide any corroborative evidence these tools were ever on the property when North Georgia was working the project, any details of the brand of tools, model numbers, or even receipts that he ever had the tools. Further, he testified he does not do construction work himself. I believe his testimony was he does not even lift a hammer. In any event, North Georgia does not have his tools or know anything about them. And then finally, the refrigerator sat in the home for over a year, no power, unclean. It doesn't take long for appliances, such as refrigerators, to get disgusting with mold and mildew, no matter the age of the appliance. Mr. French disposed of this refrigerator because it was a health hazard. In any event, the Beards are not entitled to any recovery on these claims. Thank you, Your Honor.
All right. Well, thank you very much. Now, let me tell you one thing that you can expect from me, and I just need to, make everybody aware once again of timing. I'm going to get something out. It may be just a memorandum of final judgment for one of you to prepare. So I can't make any promises that it's going to be a final document, but it will come out very, very shortly. Mr. Gowans had mentioned something at some point during, I think it was when we were talking about closing argument, attorney's fees on Friday night, that there might be a claim based on an offer. And of course, I don't want to know anything. But be aware that next Friday is my last day, and Friday week, and I won't be handling anything past the entry of this final judgment. So I just wanted to mention that. And I wanted to once again thank everybody and tell everybody how glad I was to meet you.
Thank you, Art. Can I just ask a quick question for
Sure.
point of reference? So, Mr. French's claims of fees are based on the offer of settlement pursuant to 191168. And we did the formal filing, we provided notice to Ms. Rose, obviously, unless the court enters a judgment in favor of North Georgia and 125% in excess of the offer, then that claim would die. But assuming that is what happens, how would be the best way to get that to the court in an expeditious manner?
I'm not doing anything.
So it would be the next judge that picks up the case?
Yeah, and I can further tell you, it would either be my successor, but that's a long way off. I am thinking just from practicality's sake, that's going to be much further than you're going to be interested in. There will be a senior judge handling criminal matters, and he has agreed to step in on either urgent or things that he can handle on my civil caseload. So just keep making all of the contacts that you now use, keep them abreast of what you need and what's going on.
Thank you, Your Honor.
Okay. All right.
Thank you.
Thank you all very much. It was good to see you again.
Thank you, Your Honor.
Thank
And
you.
please enjoy your retirement.
Oh, well, I just got to get there. Wait a minute now, Ms. Davis, I'm trying to find chat. Oh, wait. I can't turn us all off until I get this information. And the reason I didn't want you to say it out loud is because I do have us on YouTube.
Okay.
All right, everybody. Thanks so much.
I'm sorry, and
Judge
one
Bart?
question. Miss Rose, can you hear me? If you can put your email address
Yes.
in the chat. Oh, can you hear me?
Yes, I'll be happy to do that. And Your Honor, my clients wanted to just say a quick thank you and
Happy retirement.
Thank you. Appreciate that.
I hope yours gets off to a better start than ours.
Okay, and I'm sure Mr. French wishes me happy retirement too. All right. Thank you all very much. I may not be able to stay on long. Did you already do the,
Oh,
Do you
the,
need my, do you need my email as well, Your Honor?
I don't, I think the court reporter wanted it.
Oh, it's a court report. Okay, yeah, they have mine because I'm the one who hired him.
yes, I
Excellent.
do have yours. Okay, thank you.
Good job.
thank you,
Thanks,